Good afternoon, everyone, and welcome to Families USA's webinar on the landmark decision by Federal Judge James Boasberg that struck down HHS's approval of work requirements in Medicaid for Arkansas and Kentucky. My name is Sophia Tripoli, and I'm the Director of Healthcare Innovations at Families USA. Following the ruling, we saw an immediate impact in the states where legislatures and governors are considering Medicaid waivers and funding. We wanted to let you know today about the judge's ruling and how it may affect your efforts in states to address the work requirement issue. We also wanted to highlight that our friends at the National Health Law Program will be hosting a webinar at the beginning of next week to go more deeply into the legal ramifications of the ruling and future court considerations on an appeal or additional lawsuits. That webinar will be 2:30 to 3:30 on Monday, and we will share additional details of NHELP's webinar after today's presentation. On today's webinar, we will first hear from Kevin DeLeban from Legal Aid of Arkansas, one of the key plaintiffs in the lawsuit against work requirements, to talk about the implication of Judge Boasberg's decision in Arkansas. We will then hear from Elliot Fishman, Senior Director of Policy, who will walk through some of the key highlights from Judge Boasberg's decision, what this means for the future of work requirement proposals for the Medicaid program, and what we expect around appeals to these decisions. Next, we will dive into the implications of the decision in the states, both for those states that have pending work requirement proposals in with CMS and those states whose legislatures are currently debating work requirement bills on the floor of the legislature. And of course, we will leave plenty of time for questions. A few very quick house rules. First, a reminder that today's webinar is being recorded, and we will be sharing the recording very quickly after the webinar. If you have a question, please go ahead and type those questions into the chat box so we can get as many questions queued up as possible. And without further delay, I will turn it over to Kevin. Kevin, congratulations on a really big win. We're really excited for you to join us, and take it away.
Well, thank you, everybody. Hopefully I'm hearable. Is that right, Sophia? Can you hear me?
Yes, we can.
Can you hear me?
Thanks, Kevin.
Okay. Just making sure there was another mute thing. Well, hello, everybody. I'm Kevin DeLeban with Legal Aid of Arkansas. We are part of the litigation team with the National Health Law Program and the Southern Poverty Law Center, and assisted by Jenner and Block, and of course, all of us together. We're working to get the law, or to undertake the lawsuit and get the outcome we did. I guess the best place to start is with the people who are most directly affected, which is our clients. I called them yesterday and today, spoke with almost everybody, and the overwhelming sense from all of them was both happiness and relief. They're happy that they and other folks in their situations are no longer going to have to comply with these really onerous requirements, and just the relief that they had from knowing that they're going to have health care when they wake up tomorrow or next week or next month. And one of the things that oftentimes goes overlooked in all of the discussions is what it's like to have to live on a day-to-day basis, not knowing if you're going to be able to get your meds or have that surgery or see that doctor when you need to. And so all of them just express great relief because they can now know that they are going to have insurance. From our perspective, of course, advocates have been saying all along that this is illegal and it's harmful. And so it's a shame that 18,000 people had to lose coverage for something that we knew from the start was not going to be workable over the long run. And now for organizations, at least for my own organization, Legal Aid, and I think some of the other groups on the ground who work with and serve individuals who are on Arkansas Works, a lot of the focus is going to be on trying to get people the knowledge that they can sign back up. The state is actually forbidden by a state law, by the state legislature, from expending any resources on informing people that they can re-enroll. And so basically the 18,164 people who've been cut off have no way of knowing that they can re-enroll except a single sentence of maybe 10, 12 words in a line in a 10-page letter out of, however many 10-page letters that they got over the course of several months. And I guess the last thing I'd like to say is now that the work requirements have been ruled illegal 3 different times in 2 different states, and Arkansas's experience has showed how devastatingly harmful they've been to low-income Arkansans, that we don't see any reason why any state or federal government entity would have any interest in still trying to pursue them. We know that people are doing their best with what they have, and that most Arkansas Works recipients are working. The minority who don't work overwhelmingly have some sort of barrier to work, like caregiving responsibilities or some sort of disability. And we know that health coverage is important as a work support so that people can have the coverage they need to be healthy, to be able to continue to work. And Arkansas's experience showed that the work requirements have the exact opposite, or have the effect of undermining people's ability to work and maintain their coverage and their health needed to kind of live a full life and work. So I think with that, I'll just I think that's the end of my comments. Happy to take a question or two, and then I have to hop off.
Thank you so much, Kevin. That's really fantastic. If folks have questions for Kevin before he needs to drop off, please go ahead and type them into the chat box. We'll stand by for just a minute to see if any folks have questions for Kevin. Kevin, here's a question for you. Can you speak at all about any other states that are planning to file legal challenges that you know of?
No, I can't speak to that.
Thank you very much, Kevin.
Yeah, sorry to be so disappointing.
No, that's okay. Any other questions for Kevin about any specifics related to Arkansas?
Yeah, Zalia, I'll just say I can speak a little bit to that in the Q&A portion. Come on.
All right. I think, Kevin, we're getting a bunch of questions, but I think all things that are sort of more broadly related to work requirements, and we'll address those in the remainder of the webinar. So we will let you drop off. Good luck with the rest of your afternoon and interviews, and thank you very much for joining. We know you're a very busy day for you today, and congratulations again on the big win.
All right. Thank you to you all for hosting, and many, many thanks to InHelp and the Southern Poverty Law Center for all their hard work on behalf of families from Arkansas. Thanks, guys.
Yes, absolutely. Thank you again, Kevin. So with that, I'm going to now turn it over to Elliot, who's going to provide, Elliot Fishman, our Senior Director of Policy here at Families USA, who's going to provide an overview of the court's decision. Elliot?
Great. So I'm going to be talking at a high level about the decision, and then somewhat about the implications for this area, not just legal implications, but policy and political implications more broadly. Next slide. So this is just some basics on the decision itself. So as, of course, we've been discussing, this was a suit between the United States Department of Health and Human Services and plaintiffs in both Kentucky and Arkansas working together with Kevin, who we just heard from, with Arkansas Legal Aid, with Southern Poverty Law Center, with the National Health Law Program. As we note at the bottom of this slide, InHelp, the National Health Law Program, as Sophia also mentioned, is doing a webinar Monday afternoon at 2:30, and I think they are going to be really walking through in a granular way both the legal implications of the ruling and legal next steps. This is really the headlines in terms of the legal implications. First, that work requirements, other extra statutory restrictions on eligibility are not consistent with the objectives of the Medicaid program. So where last summer Judge Boasberg, his ruling, while it clearly seemed to be leaning in this direction, was directing the Department of Health and Human Services to consider the core objective of the Medicaid program in terms of furnishing Medicaid benefits in any future approvals or reviews. This went ahead and looked at both their reviews of Arkansas and Kentucky and was more definitive with regard to these programs are fundamentally about taking coverage away from people. And for example, we'll look at a quote in this regard, but even if one accepts, and I think the judge was rightly dubious about these arguments, but if one accepts the arguments that these promote health, that fundamentally the most important objective of the Medicaid program is to provide Medicaid benefits. Consider how intuitive and actually seemingly obvious that is, and I think that shows importantly how robust this legal finding is likely to be going forward. It is really awfully hard to argue that the Title 19 of the Social Security Act, which is titled medical assistance, is not about providing medical assistance benefits. This has implications not just for these specific waiver ideas, but more broadly as a test, right? This is now a legal test that Judge Boasberg has laid out, and any sort of waiver that is restricting eligibility at a large scale in a way that is not envisioned by the Medicaid statute is now going to have to be up against this test, which will be very challenging for any eligibility restricting waiver. Okay, let's look at a couple of the quotes on the next slide. The first quote is considering kind of the strongest possible position that the United States government could argue, which is, let's even grant that promoting health is an important objective of the Medicaid program. That is not something that in oral argument the judge was very positive towards, but let's even grant that possible assumption. And let's even grant this similarly far-fetched notion that taking Medicaid away from people in some way promotes health. The judge is saying, even here, you didn't even consider those as some sort of a package, right? So even granting the dubious arguments that the United States side was trying to make here, and that the states of Arkansas and Kentucky, this still fails the test of trying to review as a package and take seriously how little taking coverage away from people has to do with promoting the objectives of the Medicaid program. Also note in the second quote here, and this was true in both the reapproval in Kentucky and the original approval in Arkansas, how important the commenting process was. Right? And one of the really striking outcomes from this entire process has been that the creation of an administrative record through the filing of public comments really is of tremendous legal importance in the review of these demonstrations. I think that's a lesson that we at Families USA take very much to heart, and I imagine that many of those on the call are really just highly struck and motivated by that, given how dramatic the balance of those comments was in both of these two states. Okay, next slide. So thinking about implications, right? the most obvious implication is that Arkansas and Kentucky are stopped from moving forward with Medicaid work requirements. There are thousands of people in the state of Arkansas who are about to lose coverage next week. They're going to keep their health insurance, as Kevin spoke about. In Kentucky, implementation was going to move forward this summer. And in general, we are now in a position where for at least the next several months and potentially beyond, nobody is going to be losing coverage from these waivers. That's just a huge accomplishment. That's a huge accomplishment not just in terms of the politics of the Medicaid program, but that's a huge accomplishment in terms of public health in some parts of the country in which the public health story for low-income adults has been really scary and negative for the last 3 or 4 years. But as critical and dramatic as those implications are, there's also really important policy and political implications around Medicaid. So on our fourth bullet here, that this sends a clear message both to the federal government and to state policymakers in the legislature and in the executive branch. We will see how that plays out at each of those levels of decision making. It is, I think, entirely possible that there is a diversity of views quietly going on within the federal government. And one, I will say, does wonder if there's a question of prioritization around healthcare priorities with everything that is swirling around in a somewhat unclear manner in not just the Department of Health and Human Services, but the Trump administration more broadly. At the state level, though, you now have a clear sense of what you are bargaining for in trying to pursue one of these programs. So, A, you are bargaining for potentially years of litigation. B, you are bargaining for a tremendous implementation challenge that is high risk. Thinking about what led up to the judge's opinion in Arkansas, which began with the truly disturbing and heartbreaking stories of 3 of the plaintiffs who had lost health insurance coverage under the Arkansas Works Amendments, and just the terrible, detailed, deeply reported stories that were like a drumbeat coming out of Arkansas starting in the late summer of 2018. If you're a state that is entering into consideration of pursuing one of these waivers, you have to ask, even on their own terms, is it worth all that, right? So this is potentially, in an election year in Kentucky, going to be the only real Medicaid legacy of the Bevin administration as they head into what is likely to be a closer uphill battle around re-election this November. In Arkansas, their Medicaid program has been losing enrollment, even separate from this, the enrollment losses under the Medicaid work requirement. And again, has it been really taking up all the oxygen in the room when it comes to healthcare policy in the state of Arkansas for the last 2 years? So our recommendation would be to any state that is thinking about these, not just for all of the principled grounds and legal grounds, but just in terms of the practicalities of trying to administer a Medicaid program and trying not to get bogged down in a legal and operational morass that stands a really high likelihood of not coming out with anything, whether that no state should really be moving forward with this, while at a minimum, there is still a opinion that says that these are not legal. And that opinion is going to be in place until the appeals process runs through. Again, at a minimum, and we can speak to, and I'm sure NHELP will be speaking to on Monday, what the handicapping is around appeals, and I'm happy to share what we know when we get to Q&A. Okay, so next slide. So this is a reminder, and this slide is available on the Families USA website. And if you just did a search for the word grid on the Families USA website, it will take you right there. But this is a reminder of the current status of these types of waivers as of now. So if you look at the second, I guess it's the third column, and it's really the first column, which is sorted by waiver type. There are now quite a few states that are in some phase of either approval or formal proposal around Medicaid work requirements. Given that, it is particularly striking that none of these are currently operational and are likely to be operational for the indefinite future. Right, so CMS has jammed through a number of approvals that accelerated it in the latter part of 2018 and the beginning of 2019. But it is, again, quite striking, first, that none of them are operational, that there are a number of states which pushed these through last year which are pulling back on them or seriously considering pulling back on them. That's a result initially of more progressive governors winning elections in part on healthcare issues in November. But I think it is increasingly the broader, just deeply troubled environment of these waivers, both legally and operationally. So let's go to the next slide. And I'm going to hand things off to Sophia just to start to speak about how this dynamic is playing out increasingly in state legislative debates.
Awesome. Thank you very much, Elliot. As Elliot mentioned, the Boasberg decision sends a clear message to state lawmakers that they should not be moving forward with work requirement proposals at this time. It will be critical to see how Governors Bevin and Hutchinson respond to Judge Boasberg's ruling, particularly around the threat of coverage loss for the expansion population now that work requirements have been struck down. Just today, we saw Governor Hutchinson announce that he will urge federal officials to seek an expedited appeal, but also encourage state lawmakers to approve funding of the current Medicaid program while the issue is on appeal. Advocates should be ready to respond to those types of threats in the event that they should occur. Looking at state action on work requirements in the legislative sessions, there are a few key states that are weighing legislation in the wake of the ruling. Idaho lawmakers have been pushing a work requirement bill for their Medicaid expansion population. HB 277 passed out of the House last week and was before the Senate committee yesterday. It now appears that the Senate has put the bill on hold in light of the court decision. But it will be critical to see how things play out in the legislature, particularly as Governor Little has indicated that he will not let the session adjourn until Medicaid expansion is funded and resolved in the state. Montana legislatures are also considering a work requirement bill alongside their efforts to extend Medicaid expansion, which is set to expire at the end of the year. HB 0658 includes an extension of the Medicaid expansion bill with a work requirement program and was endorsed by House committee. Iowa legislatures have also been pursuing a work requirement bill. The bill passed out of the Senate last week, but House leadership has indicated that they will not be moving forward with taking up the bill at this time. So we'll be watching closely to see how things progress there. And then just finally, this was notated on the grid that we just saw, but I did want to note that the National Health Law Program, along with plaintiffs, have filed a lawsuit against work requirements in the work requirement waiver proposal in New Hampshire. And another quick reminder to folks that it's important to be paying attention to this lawsuit as we sort of see how it progresses. I think with that, those are sort of the key states that we should be keeping an eye on in the legislative session. Kansas I didn't mention, but they have right now a Medicaid expansion bill moving through the legislature with a work referral program, so it'll be interesting to see how we'll be keeping a close eye on how things progress there. But with that, I do want to stop and open up some time for some questions. Again, if you have questions, please go ahead and type them into the chat box, and we will try to get through as many as possible. I did just want to put out another reminder that following the webinar, we will be sending out a bunch of resources for folks on work requirements, including the full decisions, along with a few other resources that we will put together and send out. So if you have any questions, please go ahead and enter them into the chat box. Elliot, I'm going to hand you this first one. Can you talk a little bit about how the impact of the court decision might play out in states like Virginia?
So I think that much remains to be seen in states like Virginia and North Carolina, in which Virginia has implemented expansion, North Carolina is considering it. But there's been now just a very vivid demonstration of how legally questionable this whole approach is. There is clearly a popular will in Virginia to get Virginians covered, right? That was one of the drivers of the gubernatorial election and the pretty dramatic legislative election results in Virginia just a little over a year ago. It's potentially an issue in legislative elections in Virginia this fall. And it's just hard to imagine that in a state where there's clearly such a strong popular and political will to just move forward and get people covered, that there's not going to be some serious consideration of what the state is potentially in for trying to implement one of these programs.
So does this decision set a precedent that other states have to follow, or will we need to see lawsuits in each state to stop work requirements?
So there's no legal mechanism in this decision that is applicable. And that's the literal answer to your question. On the other hand, none of the legal reasoning in this decision is in any way limited to Arkansas or Kentucky. And I would say it's particularly important to note that even though it is true that implementation in Arkansas had issues with it, that the implementation questions around Arkansas that were specific to that state really didn't have much to do with the judge's decision. So the reasoning is clearly applicable in other states, but as a matter of procedure, the legal holding is only applicable to these two states.
This question is a little bit more specific to Utah, where the legislature is working on a series of waivers that are legally questionable. Does the court decision on work requirements give anyone any hope on other types of waivers down in Utah?
So there's a lot that remains to play out in Utah, and I think it's hard to be too definitive on how the waivers will move out there. we, as well as the majority of voters in Utah, were terribly disappointed to see the legislature mess with the clear results around doing a straight-up expansion that was approved by ballot initiative there. And that decision was brazenly repealed by the legislature, and they set up a process which is murky in its implications, can lead to, at the end of that process, getting back to what the voters approved. But there are a number of steps that would need to go through, and I think it's not at all clear how that's going to play out. But certainly the state legislators of Utah were, I think, not being responsible in terms of the risks associated to their expansion, given what was already a fairly predictable legal outcome at the time that they made their decisions. So we are certainly hopeful and pushing for at least some significant expansion of coverage to move forward in the time frame that the voters approved in Utah. But it is hard to be too definitive about what's going to happen there.
Thank you, Elliot. Elliot, can you speak a little bit about what we think HHS will do next? Do they have options? What are their options now that these two waivers have been vacated?
So, first of all, I encourage, as we've mentioned a couple of times, for people to call into the National Health Law Program webinar on Monday afternoon in terms of their understanding of HHS's options now. But this is a different phase than the original remand back to the Centers for Medicare and Medicaid Services. HHS could have the option to try again with this court, that is, to reapprove and try again, as they did the first time. However, given that they tried that route once, I think our best understanding is that another option, which will likely be under serious consideration, will be to appeal and to move on to the appellate level in the federal courts.
We are just looking at questions now. Ellie, can you speak a little bit about sort of the language about how CMS didn't attend to public comments? Is this something that's helpful in lawsuits against actions by other agencies?
Yeah. So I think that the standard that the judge was using for review in terms of the arbitrary and capricious standard is a general standard when it comes to executive branch actions that involve a congressional grant of executive branch authority, which is what's in play here, right? So the executive branch has a lot of latitude, but if they do something that is so contrary to the grant of authority that Congress gave them, that can be considered arbitrary and capricious. And blowing off thousands of comments that say don't do what you just do is an important factor in determining that the federal government did something arbitrary and capricious, and that will be true across agencies. One specific note here is that the statute sets up formal comment requirements for 1115 waivers, and that is often true but not always true for executive branch actions that are happening under some sort of a statutory structure. So that I don't want to say that every process has that same emphasis on public comments that Medicaid waivers do, but I think many of them do.
Elliot, this next question is specific to Indiana, where they were really close to rolling out their web portal to start tracking work hours for and personal information for Medicaid beneficiaries. So to clarify, will that process in Indiana be put on hold, or will there need to be a specific lawsuit filed in Indiana to stop work requirements from moving forward?
Yeah, thank you for the question. So we had language that question is referencing in terms of what the implications of this decision are, where we were indicating that our recommendation would be that states should put these on hold until appeals are exhausted. We didn't mean that is the legal implication for the state of Indiana or any state other than Arkansas or Kentucky, right? So Indiana at this point can legally move forward. The court did not rule on Indiana's waiver, but given that Indiana's program looks an awful lot like these programs and I think is likely to be challenged in the same way and potentially with the same judge, our, and not just our, clear implication for the state of Indiana would be you shouldn't just pretend this didn't happen and move forward. If you're being responsible, you need to let this legal process play out before you make a decision involving your taxpayers' dollars and coverage for low-income people in your state.
Thank you, Elliot. This next question is about sort of what we might anticipate Governor Bevin to do, whether he will terminate Medicaid expansion in Kentucky because of this decision. I think I'll start and then let Elliot pick up anything. I think Governor Bevin has certainly indicated that that's something he might consider. I think we're watching very closely to see how he might react to it. At this point, I don't think we can say definitively in either direction, but I do think it is a possibility and something that advocates on the ground there have been preparing for and will be ready to respond to in the event that Governor Bevin does try to move in that direction. Again, if folks have questions, please go ahead and type them into the chat. This one is a question about sort of the court procedures. How is it that why is it that all of these cases end up before the same judge? What's the mechanism that sort of moves these cases through the court system?
So that is also a great question for NHELP, although I'll give the basics of it. The main defendant in these suits is the Department of Health and Human Services, right? So the states are sort of co-defendants in these suits. But the main defendant is the federal government, which is why these cases are heard in Washington, D.C., in the district court in Washington, D.C., where the Department of Health and Human Services is located. And I think it's very typical for cases that are closely related to one another to be grouped together with one judge in that district. So, for example, there is another judge in the district court in District of Columbia that is hearing a lot of cases that are coming out of the Mueller report investigation, right, in the same courthouse. And again, that's very typical that you're going to have one judge that's working on a series of cases all around the same broad issue.
So there are a couple questions about other states that are pursuing legal challenges. We talked a little bit in the webinar that the National Health Law Program, along with plaintiffs in New Hampshire, have filed a lawsuit challenging the legality of work requirements in their waiver proposal. So that is certainly a legal challenge that folks should be paying attention to. And then there's a question about work requirements applying to the expansion population versus traditional population. And for that one, I'd like to turn folks to our grid that we had a slide on this. That's available on our website, and we'll send that out as part of the resources following the webinar. But in that grid, it details all of the states that have work requirement proposals pending in sort of the status of where they may be in their proposals, either with CMS or early on, and it also indicates which populations the work requirements would apply to, whether it's the expansion population, traditional. So I will point you to that as a resource to look at. Here's another question for us, Elliot. Given that work requirements are so important for some conservative legislatures, do you think this decision makes it tougher for red states to move to Medicaid expansion? It's a really great question.
So I think that the underlying dynamic that is going on around Medicaid expansion is that, particularly following on the ballot initiative wins in 3 very red states in Idaho, Utah, and Nebraska, that there's fundamental increasing clarity that this is something that people want in states regardless of political ideology, that this is just fundamentally an idea whose time has come, and that people want coverage. That being said, in any specific state, there are going to be political dynamics in that specific state, and that's something that we at Families USA have always really understood, and there's even after this court ruling, the politics around work requirements and expansion in a given non-expansion state may be distinctive to that state, and we respect that.
Do we have a sense of whether there will be a specific remedy in Arkansas for the 18,000 people who have already lost coverage there as a result of the work requirement waiver, and whether their coverage will be reinstated?
So those 18,000 people already were eligible to apply for reinstatement for their coverage. One of the particularly frustrating and predictably self-sabotaging aspects of this waiver is that the assumption that you can just without a process of really being able to effectively communicate with people, that you can just let 19 or 18,000 people lose their health insurance coverage and that they'll come back is just counter to the entire experience around eligibility determinations, not just in the Medicaid program, but for health insurance more broadly. But in terms of a remedy for those people who have already lost coverage, our understanding is we're still, working to try to track them down and get them back on.
Thanks, Elliot. So I just want to address a really important point about the impact of the waivers, the vacating of the waivers, the decision. So importantly, in states that have work requirement waivers approved, the decision, Judge Boasberg's decision does not stop those other states from moving forward with implementing their work requirements. It just stops Arkansas and Kentucky right now. What we're saying is there are implications for those other states, for lawmakers, for governors, for legislatures, and for HHS to look up and to take pause at the decision to continue moving forward with implementation. But it will take a lawsuit in other states, like in New Hampshire, where they've just recently filed to stop the implementation of work requirements and to make sure that folks are not losing coverage. So that's a really, really important, thank you for all the folks who are asking that clarifying question. That's a critical piece to make sure we all understand walking away today. Elliot, do you have a reaction to Governor Hutchinson's claim today that 95,000 people have gotten jobs and that's why they were disenrolled from the Medicaid program?
So our reaction to that is there's zero evidence that that's the case, and more generally that it really seems like not just Governor Hutchinson, but more broadly the Hutchinson administration in Arkansas has been in denial about what the country has seen as the outcomes from this waiver program, and what the judge very clearly described as the outcomes from this waiver program. There have been, as recently as a couple of days ago in the Washington Post, in the Arkansas Times, in the Democrat Gazette, in Politico, there has just been one story after another of people not only who lost health insurance and did not get employer coverage in Arkansas because of this waiver, but people who had jobs and lost their jobs because they needed health coverage to keep them able to work. So that's just a kind of a bedtime story that Governor Hutchinson is trying to tell himself, and a rationalization, not an evidence-based claim.
Thank you so much, everyone, for all these excellent questions. We will be circulating resources following this webinar, including the full decisions, this slide deck, and a few other helpful pieces of information. We'll include the link to the grid for the waiver grid so folks can take a more in-depth look to see where states are in the process of their work requirement proposals, and understanding which states have work requirement proposals that apply to the traditional Medicaid program versus the Medicaid expansion program. We'll also include, send out a recording of this webinar. I will just give another minute to see if there are any sort of final questions. Is there a place we can go to track ongoing lawsuits against work requirement programs? That's a really great question. I think certainly the National Health Law Program is an organization that you'll want to follow. They post up-to-date information on sort of which lawsuits they're involved in. Here at Families USA, we will also be tracking lawsuits right now. In addition to the Arkansas and Kentucky decision, the only other lawsuit around work requirements is the New Hampshire lawsuit that was just filed last week. So as that progresses, we'll be sure to keep folks informed, as well as informed about other lawsuits that might be coming down the pipeline. So thank you guys very much. Let's just give one more minute for any final questions. All right, thank you very much to everybody for joining today. We will be following up with some resources. If you have any additional questions, please feel free to reach out to the contact information on the final slide here. We appreciate your time, and we will be talking soon. Thank you, Elliot, for fielding a round of questions. Much appreciated. Thanks, everyone.